excuse Commissioner Martinez. He is in Denver for a coal-impacted communities conference with the National Association of Counties. It's possibly a way that we can get some help from the federal government to help our economy here, so please excuse him. First on the agenda is the approval of minutes. We have one set of minutes from the April 17th meeting. Testing. We got it now?
Now
Hey,
it's
we got
live.
sound. Let's move forward from there.
There you go.
Thanks, Barry. Well, is it still on? Okay. Here we go.
So anyway, I don't have the grant. The grant's done through emergency management, so I don't even know a lot about it, but I can tell you what we do with it and how that we utilize it. It's a grant for bulletproof vests for our deputy sheriffs to have. And I'm not sure, is there a county match?
It does. I can't see where it talks about a county match in here.
So-
I remember someone's brought this up just recently, and I think there is a match, but it comes out of Justin's grant money.
SHASP or whatever, probably. So that's kind of what I thought as well. And the way that we've done it, the vests are good for 5 years at a time. So they're guaranteed for 5 years. We've got them on a rotation to where we don't replace them all every 5 years. They trickle in every year. We replace some, so they're kind of on a little rotation. We're always seeking vendors that have the level of vests we would like to have and get the best deal. So they'll come down and display their products, and we'll see if we can get a better deal than we got last time around. But that's what they're for. They're for the guys to have the vests. As far as I know, and I hate to mislead you, I don't think the county pays anything out of county funds for these vests. So, but we could hold that. I don't know that we're in a huge hurry. We may could hold it till next time if you want me to get more details.
He's correct. There is a match. It's a small one from the county. I don't remember the exact amount. It does come out of Jeremy's budget. But yeah, it's
grant.
not county funds.
So, okay.
I think this is an important thing to move forward on. The safety of our officers is important. That's my general opinion.
Mine too. I'm okay with it. So I'll make the motion that we approve the grant application for 2019 bulletproof vests.
I'll step down and second that. All in favor?
Aye.
Aye. Motion
Thank you.
passes. Thank you. Item number 4 on the agenda is review and possible award of airport remodel bid. Seth, did you want to cover this since you were in charge of opening the bids? We received these bids last week, opened them, turned them over for review. I guess we could just read those in. There was really not much to the bids. There wasn't a whole lot to look at, just basically the cost of the 2 bids. We received 2 bids, one from Bodeck Electric for $226,515.60. The next bid was from Stilson and Sons Construction, and their bid was $239,600. So I guess unless there's questions, we just need to award the contract. The apparent low bidder is Bodeck Electric.
I have no questions.
Okay.
So I'll make the motion that we accept the low bid from Bodeck Electric for $226,515.60 for the renovation work at the classroom for USU Eastern at the airport.
I'll step down and second that. All in favor?
Aye.
Aye. I guess we've talked about it before, but this is going towards USU Eastern's aviation program that's coming from the Logan campus to here. They're overflowing at Logan, and they're expanding their airport project here. This is just to give them some classroom space. Item number 5, consideration and possible approval of ordinance number 516, amending the Carbon County procurement policy pertaining to the sale of real property. Christian has asked that this be tabled to allow a little further discussion and review with the property rights ombudsman. So if we can have a motion to table.
I'll make the motion to table item 5.
I'll step down and second that. All in favor?
Aye.
Aye. Item number 6, public hearing to receive public comment on proposed amendments to the Carbon County Development Code, Section 3, zoning general requirements, Section 5, large and small scale developments, Section 6, subdivisions, and Section 7, performance guarantees.
Commissioners, can I introduce those items, if you don't mind? In Section 3, the change that's being proposed is a change that is found in, let me find it for you here. There's just one, really, only one substantive change in that whole section.
It's page 3-11.
Yes, that was it. 3-11. It's section 3.3.27 pertaining to caretaker dwellings. The change that's proposed there is that caretaker dwellings may be permitted upon approval by the zoning administrator rather than by the planning commission, as was the case previously. Since we have caretaker dwellings already defined in our definition section, it's a relatively simple matter to determine whether or not a caretaker dwelling is allowed in the zone or not. And so the proposal was that something that simple be allowed to be determined by the zoning administrator himself. Caretaker dwellings are generally quite small. There's a limited number of space that can be in them, and and they can only have certain number of rooms and amenities. So they'll either be allowed or not. And so the thought was that it would be simple to allow the zoning administrator to just make that decision. That was the change in Section 3. my suggestion would be that maybe we do a public hearing with respect to each section. Would that be all right? And then
That would be
we don't get confused with respect to each one.
Okay. If there's nothing further as far as explanation, we'll open this public hearing at 4:41. Anybody that would like to speak to Section 3 zoning requirements, please come to the mic and state your name and give us your comments.
My name is Lena Topolovic, and I'm just here to talk to section 3.3.9. I don't know if it's been changed, but the latest copy that I received from Planning and Zoning still had the information on storing commercial vehicles in residential zones. I've brought this up to the zoning commission, and I still have issues with the way that this is worded. First of all, the first line of that section indicates that you can't have that type of equipment in R1 20,000, 1 8,000, 2 8,000, and 4 8,000 zones. However, the next line basically says as long as you have, you can have those particular semi-tractors without a trailer on any property. It doesn't restrict it in any fashion as long as it doesn't obstruct the road, sidewalk, or any intersections. My whole concern with this is that with this change, we are introducing an industrial use into a residential zones. Now it's restricted, say, on the 20,000, but out in the county, you may have an RR1 right next to an R1 20,000. But the RR1's going to allow, according to this, that you can park that vehicle on that property. It's still going to impact the 20,000s, the 8,000s, and so forth. The big concern that I have are the stopping distances with trucks of that size. You know it takes a lot longer to stop them, especially loaded or unloaded. There's a difference there. The road impacts and the weight limits on those roads and the amount of asphalt that you might have in a residential zone versus on a commercial road or a larger road, and according to the county's road requirements. The noise from Jake brakes, etc., the fumes from idling the trucks to warm them up, and all in all, we're going against the legislative intent of the residential zones by introducing a commercial and an industrial use into the residential zones. So I would request that you make a change to eliminate those impacts to residential zones. Thank you.
Thank you. Seeing no one else wanting to speak to Section 3, we'll close this public hearing at 4:44. Do you
Commissioners,
want to approve these one at a time as well?
No, I think let's have all the public hearings and then go through the approvals,
Okay.
since that's how it is on the agenda. I just point out on section 3.3.9, none of what I'm there are no suggested changes to 3.3.9 with that are before you today. It's not inappropriate for Ms. Topolovic to ask that you make such a change, but 3.3.9 has not been changed or amended. That's simply how it is right now. So, and she is correct. As it's written, it would allow semi-tractors to be parked on the owner's property in any zone. However, as written, it restricts construction equipment and semi-tractors with trailers from being in any residential zone that's essentially less than half an acre. So, but tractors, semi-tractors could be allowed in any zone as it's written. So
So we're for this, we're simply on the amendments that have been proposed.
Yes, I mean,
Wh-
you
when-
can certainly recommend a change based on that public comment that you've received or recommend it be looked into. But I just want you to be aware that that section is not being changed
Okay.
today, so. Or what's being proposed is not a change to that section.
Okay. The next public hearing will be on section number 5, section 5. We'll open that public hearing at 4:46. Anybody that would like to speak to that, please come to the mic. Again,
Commissioner,
state your name.
can I just introduce that one
Oh,
also?
yeah. Well, let's hold off on the opening of the public hearing. Let's introduce it, and then we'll go into the public hearing.
Okay. So the change that's being requested here is an additional section to conditions that can be imposed through a conditional use permit. And the change is on page 5-7, subsection 5.1.9, subparagraph C. And that section says that the county, to mitigate a conditional use or the detrimental effects of a conditional use, may A, require the posting of a reclamation bond or other security for the restoration of real property to its previous state, including reestablishing previously existing contours and conditions, for the removal of unsightly, dangerous, or hazardous conditions or waste, or for the removal of nuisances, or for the removal of mitigation of any other conditions that are reasonably foreseeable to cause harm to the public welfare. So the intent of that is to give you, or to give the County Planning Commission, when it grants a conditional use permit, broad authority to require the posting of security for reclamation purposes and mitigation purposes. There are also a couple sections where previously the Site Plan Review Committee or the County Commission approved certain projects, but now the authority has been changed to just be the Planning Commission itself. As you know, the Planning Commission is the body that approves subdivisions at this point, and the County Commission does not do so. So similarly, there have been changes in 5.6 to allow planned unit developments to be approved by the Planning Commission. Condominium projects and condominium conversion projects in sections 5.7 and 5.8 can be approved by the Planning Commission alone. Factory-built housing parks can be approved by the Planning Commission alone. Planned shopping center developments can be approved by the Planning Commission alone. And mountain recreation developments and recreational vehicle courts can all be approved by the Planning Commission alone. As can hotels, motels, and apartments. So the major utility transmission projects or major industrial projects still require approval by the County Commission as well as the Planning Commission. So those are the changes to Section 5.
Okay. Now we'll open up the public hearing at 5:49. What's that? Excuse me, 4:49. It's closer to the 5. 4:49. Anybody that would like to speak to this, please come to the mic and state your name for the record.
Ken Snook, just a comment. This is a new change, correct, on Planning Commission alone on those items?
That's correct.
Is it recommended by the commissioners also on that?
Well, that's what we're here to decide. I mean, that's the next discussion item on the agenda, is whether they agree with that, or whether they want to keep that under their own jurisdiction. The point of this is to, a couple of reasons that subdivisions were not required to be approved by both the county commission and the planning commission is that double approval oftentimes, well, first of all, everything's looked at by the zoning administrator to make sure you've met all the requirements. The planning commission then looks at those plans, looks at the plat, looks to see if engineering requirements have been met. All of those things are requirements have to be met before they're even submitted to the planning commission. Previously, after the planning commission approved it, it went to the county commission. Recent changes in state law state that unless there is a compelling countervailing public interest in not approving a land use application, you must approve it. So it's not simply a matter of discretion by either of the boards. So a determination was made that it was fairly redundant in having two bodies look at this, look at each of these kinds of developments, because they tend to slow down a developer in exercising his rights, when generally if he meets the application requirements, he's entitled to approval even if it's an unpopular project. So the thought was that generally if a developer can meet those application requirements, it's a very rare situation where there will be a compelling countervailing reason why you wouldn't be approved. So this was meant to streamline these processes.
I just have seen that in Salt Lake County that there's been public outcry on some projects, and streamlining it may be good for all projects, but once in a while there might be a project where the commissioner's public relations might be involved. So I kind of disagree with the streamlining.
Okay. Seeing no one else, Lena, you want to come up? Okay.
On this particular section, my only concern is that we make sure that the public has some facility to have public comments on these kinds of developments, etc. Because those people that have to live in the particular area, and the board does not cover all the areas in the county necessarily, those board members, we're looking at it from all angles and seeing all the issues that might result from a subdivision to make sure that we have public comment.
Thank you.
And I would point out that as the code is written, these approvals that are contained in section 5 for these different kinds of plans, they do not require public comment to receive approval. They do require approval from the planning commission, but for example, a planned shopping center development, a recreational vehicle court, mountain home development does not as written require, or if you were to approve it, it would not require an approval. It would not require a public hearing. It would simply require planning commission approval.
So talking about housing, what would require a public hearing?
Basically, major industrial projects, major utility projects,
But general housing
type things, general commercial retail type developments do not require that.
Okay.
Again, the state code is pretty and here's the rationale for it, and this is not meant to be me advocating for that, but this is the reason why why the Todd Thorne in planning and the planning commission thought to do this again is the law states that if you've met all the conditions of an application, and we have fairly specific conditions that you have to meet, if you meet those conditions, you're entitled to approval for unless there's a compelling countervailing public interest why you shouldn't be.
So in that situation where there is a compelling argument,
Mm-hmm.
a group of people have gotten together or whatever, what is their avenue to have that public hearing or a process? Say a subdivision is proposed, and there's a number of people that don't want that subdivision for a number of reasons. What is their avenue?
I don't know that they have one because there is a requirement that notice be published of the approval, and then I believe you have the right to appeal that, but they don't have the right to, but there's no avenue for them to come in and inform there's no formal avenue for them to come in and inform the planning commission that they don't like that. Here's the reason is the Utah Supreme Court has said public clamor by and of itself does not constitute grounds to deny a project. In other words, you can't say, I don't like this here. You must say something to the effect that this is going to endanger us, this is going to cause us health problems, and here are studies by engineers and experts in these fields that state that this type of project this close to somebody's house is likely to cause problems. It's not enough to say this is going to increase traffic and my kids play in my front yard, for example. Speculative reasons are not, the Supreme Court has held those are not sufficient. Those kinds of reasons are allowed in a zone change, and that's a grounds for not changing a zone, but it's not a grounds for denying a specific project, and a project that would require a conditional use permit. So there is not a public hearing requirement on a lot of these things, simply because the average lay person doesn't come in with scientific or fact-based evidence. They typically come in and say, we don't like this in our neighborhood, which there's no doubt of their sincerity, but can they prove it's going to be detrimental? Typically, 95% of the time, it's hard to marshal that kind of evidence. So,
Thank you. Anyone else that would like to speak to this? We'll close this public hearing at 4:57. Next section is section 6. Christian.
Commissioners, a few sections in here. Section 6.3.5, subparagraph K, it's been suggested that we add language that indicates what kind of engineer calculations and drawings should be included, including plans and profiles showing the finished grade at street locations and cross sections of street pavements, including curbs and gutters, locations of street signs, location, size, and elevation of storm drains, sewers, fire hydrants, water systems, and utility systems, descriptions of any existing facilities or utilities. So in other words, we want to make sure the Planning Commission is acting on detailed and specific information, and the developer is committed to developing the project very specifically, and that so that the county can then say if something's not set right, developer, you need to go back and put this in as you said in your plans. 6.3.8, there's a change that says approval of a final plan shall remain valid for a period of 1 year. Said approval may be extended or reaffirmed by the Planning Commission for a period not to exceed 1 year. So your approval is good for a year. If you don't get it developed, you can ask for an additional year. In section 6.10, we indicate that if excavation, installation of utilities, roadways, or street construction or other construction commences in a subdivision before final approval of the Planning Commission and before a financial guarantee has been submitted, there would be an administrative fine that I would recommend be somewhere around $10,000, and that the subdivision be deemed an illegal subdivision. In other words, developers need to know that they're not to proceed until everything has been approved. Also, we change section 6.10 to provide that if you begin to, if you take action to illegally develop a subdivision, it's a Class B misdemeanor. I believe those are the changes to section 6. So they're meant to give us some more teeth in ensuring that developments are done right, and that developers are on notice that penalties will be severe if subdivisions are illegally commenced.
Okay. We'll open up this public hearing at 5:01. Anybody that would like to speak to this, again, please state your name for the record. Last call. Okay, we'll close this public hearing at 5:02. And section 7.
Commissioners, the change in this section is to state that when deciding what amount the county is to require for a performance guarantee for the installation of public improvements, that guarantee under section 7.2 should be based on an amount not less than 125% of the average of 3 cost estimates from qualified contractors or engineers regularly performing the type of work for which the guarantee is requested. I would also suggest you make a change in there that says the county engineer would have discretion to approve fewer than 3 estimates in the event that 3 estimates cannot be obtained locally, that he can approve a single estimate if he finds it's reasonable. So the purpose of this is to ensure that the financial guarantee developers post are reasonable and based on real actual bids, and make sure there's not a single, that we're not just getting a bid that's by a favored contractor who might be inclined to reduce it as a favor. So
Okay.
it's an effort to get a more accurate number for performance guarantee.
We'll now open section 7 for public comment. It's 5:03. Seeing no one urgently coming to the mic, we'll close this at 5:04. That completes all the sections. Item number 7, review and possible adoption of ordinance 515, amending sections 3, 5, 6, and 7 of the Carbon County Development Code. I guess we just need to make decisions if there are changes we want to make to that, or
Sure.
approve them all,
Yes,
or approve some, or
right, and approve them some conditionally. If you want additional material put in there, you can request that as well.
so in section 7, when the motion is made, I would agree with adding that one estimate, as long as the county engineer approves it, however that language, I would be favorable to that amendment on section 7.
I would, I would too. That makes sense.
I saw nothing major in section 6. Section 5. I guess my only comment there is, not that the public would change anything, if they qualify, but maybe there is something that the developer could hear that he could address in the project if there was a public hearing process. I know it's not required, but that would be my only concern. Not that I don't think it would change the development from going forward, but if there were specific things that the developer could do during the process to mitigate some of the concerns, I guess that's one of my
Would you want us to go back and look and see if we could maybe tailor some kind of public notice provisions to some of those? In other words, there were a lot of different sections here. This
Right.
is, section 5 is meant to kind of be a catch-all for all the different hodgepodge of rarely used, but occasionally used types of developments. So we could go back and look at that and see if you'd like us to come up with some creative ways to give more notice or better notice.
I guess my question is that it seems like the complaints or the worries of residents around some of these developments, the county can't impose additional requirements over and above the standard that they've been given, and if they meet those, even though there's complaints, it wouldn't hold up in court.
No, it wouldn't. What the thing that would have to happen is those neighbors would have to have an engineer that they bring in and say, hey, I've got a study that counters what you think is safe here. And so the stereotypical angry neighbor again and again has been told by the Supreme Court, we're sorry, but that's not sufficient. Your dislike of it is not sufficient. So it just seems like very often that what's brought to us is general angst and discomfort at the development, but not hard evidence. And that it's not us, it's the Supreme Court that says that evidence has to be of a type that's verifiable and scientific and of real substance. It's not just, it has to be based on some real facts.
So is there a process if somebody were to come up with some evidence of that nature?
There's not a formal process right now. It basically, you would have to hope you saw it on an agenda of the planning commission and brought it to the attention of the planning commission or the zoning administrator before the hearing. So you're right.
But there's
that's
not a
tough.
well, I guess the hearing before the planning commission. My mind went to public hearing, but there is a hearing.
There
before
is a
the
hearing
planning
before the
commission.
planning commission, but it's not advertised as a public hearing.
Correct.
So
So I guess maybe my other thought would be, is notice given to any surrounding properties?
it's typically not on something like this. It's typically only given on a zone change.
Okay.
So, I'm happy to look at that and seeing if we can't make some recommendations on that if you'd like.
I'm thinking too that, during the planning and zoning meetings, they always offer time to people if they have something to say, and in that setting it could be addressed.
They typically
It
do.
could-
That's right.
could have
But they
a-
were not required to.
That's right, but that is a setting if if people are aware of it.
Correct.
I guess I'm, the part of what we're trying to do in the county is streamline and make things not so difficult for developers and for industry who are moving here. And if we're going to expand our tax base, which is critical for us, those who are coming here don't want to be held up and be dragged through the dirt unnecessarily. And there's a lot of hours that go in to working with these folks before we ever get to a planning and zoning meeting. And so I agree with the streamlining. And if all we do is listen to public comment and it's a for naught anyway, which seems to be what I witness,
That's
then
been my experience as well.
I'm okay with the changes that they
Okay.
proposed so that we don't hold it up. So,
Okay, so no changes to section 5. And then section 3, there were some concerns there as well. I guess, Christian, my other question is, I received comments from somebody that emailed some comments to the commission. Can we add those to?
I think that would be fine.
So
That would be
Lori,
appropriate,
I'll
sure.
get you a copy of those. Those were from Cheryl Lupo.
And
We'll
you
add those to the record.
Probably ought to read those in, or at least summarize them, if you don't mind.
you want me to read them?
Yeah.
The attached is 3.3.9, which looks like there are no changes have been made. 3.3.9 needs to have all residential properties throughout the county listed. I will not be able to attend this afternoon's commission meeting. I have had discussions about section 7, 6, 3, and 5 with Lena Topolovic, and I would like it to be noted that I concur with her on section 7, 6, 3, and 5. Also, I would like to have a discussion further about 3.3.9, storage of commercial vehicles, so that you all understand what is really going on with the commercial vehicles that are in a residential area on North Spring Glen Road. This is just not a matter of all the residents on this lane wanting something done, but all the commercial vehicles that travel on North Spring Glen Road. It is also about the safety of the vehicles on the road and the people that live on the road. Before I go any further, I would like to know if a more detailed discussion in the future would be possible. I surely don't want to go into any details with the research that I have done to waste anyone's time. Please let me know at your earliest convenience, and it's signed Cheryl Lupo.
Okay. We'll get a copy of that for the record. Okay. Any other considerations on section 3?
The way that it's written, and Christian, you've explained it, and I agree with what you are explaining, that a owner-operator of a semi-truck could leave the trailer at some other place and park the tractor trailer on their property if they have room on their property to park it.
Just the tractor itself.
Just a tractor.
Correct. And as I read that, I believe that, as it's written, that's allowed in any zone right now.
No size of their property limiting any of it, if they
There's
can
not.
park it on the property.
The sole limit being whether you can make your tractor fit on your property.
Okay. There are quite a few people in the county who are owner-operators and do that, and though it might be a little inconvenient for those around them, I think it's reasonable that they should be able to park them on their lot. So I'm all right with the way it's written myself.
Okay. And I'm aware of this issue with Cheryl Lupo that she's talking about, and it's a trucking company that's operating out of a area in Spring Glen. It's a different situation than what we're talking about here. It is I understand it is in a residential zone, but it's grandfathered in as well. It's been there for a long time, so that's something else we would have to address in a different way. Even if we were to take commercial trucks out, they would still be grandfathered in, and that's my understanding. So, so now that we've discussed that, we have ordinance 515 before us. We have one friendly amendment to add on section 7. Anything else?
I don't have anything else with that
Okay.
one change in section 7. I'd make the motion that we adopt, ordinance 515, amending sections 3, 5, 6, and 7 of the Carbon County Development Code.
I'll step down and second that. All in favor?
Aye.
Aye. Item number 8, public hearing on a change to the Carbon County zoning map from I-1 to RR1 on parcel 02-1716-43 located at 2500 South, 160 East for Linda Ballard. Linda, do you want to present this or do you want Christian?
Let's let Linda start.
Linda?
All it is I have a lot that's south of my home that's zoned industrial, so I would like to rezone it to residential so that I can possibly sell it for a residential lot.
And Linda, are there other residential lots next to it or near it?
It's right in Circle K subdivision. I mean, it's not part of Circle K subdivision, but yeah, it's all residential around it pretty much.
And it adjoins Circle K, it's right next to it.
It does, it's next to my home, yes. So.
And just one other question, Linda. Is there anything on it right now?
No.
It's a vacant lot, okay. Are there other industrial lots that are adjacent to it?
To the south, farther south is UPS.
Is that right next door to it? It does touch the UPS lot?
It doesn't touch it, there's a road that comes in,
Okay,
and then UPS.
okay, thanks.
I don't have any questions.
Okay,
I would move that we.
we need to have a public
oh,
hearing
have a
first.
public hearing.
We'll open our public hearing at 5:17. Anybody that would like to speak to this, please come to the mic and state your name. $5:17, is that what you were asking? Seeing nobody jumping and running to speak to this, we'll go ahead and close it at 5:18. Which moves us to item number 9, review and possible adoption of ordinance 514, a change to the Carbon County zoning map from I-1 to RR1 on parcel 02-1716-43 located at 2500 South, 160 East for Linda Ballard.
I'll make the motion that we approve ordinance 514 and change the zone from I-1 to RR1.
I'll step down and second that. All in favor?
Aye.
Aye. Motion passes. I'll step down and motion to adjourn. We are adjourned. Buckle up and drive